Um, my name is Weber Alston. I am a estate planning attorney and real estate attorney. I've been practicing for about 15 years. Those of you all that have been customers with Scott Murray and Associates in the past may or may not know me. About 2 years ago, I started working with Scott and transitioned to take over his practice. We operate in Georgia, Tennessee, Alabama, and we do real estate transactions all over the country. I am very thankful for you all to join us today and look forward to kind of diving in and getting a start here. Um, I do ask if you don't mind, please mute your microphones if they're not already muted. We will kind of work through the presentation. We have some limited time this morning or this afternoon together, and I will reserve some time for questions at the end. Alternatively, you can reach out to us, and we will be reaching out to you all immediately after this for next steps as far as what you'd like to do if you want any kind of more information on anything that we've discussed today in greater detail. So with that, we'll go ahead and dive in and get started. All right, so as far as estate planning is concerned, if you've done this before, then this is going to be a little bit of a refresher for you. If you haven't done it before, then there's going to be kind of a lot to cover. So we're going to be covering some stuff at really kind of a higher level, broad level. Again, you can contact us and you can schedule a consultation to go through this one-on-one after today. But today's agenda is really to, number one, to kind of understand estate planning. What does that mean? What is in my estate? What do I need to do? What happens if I don't do anything, right? And that brings up number two, what are the components of a comprehensive estate plan? What do I need to do to ensure peace of mind for both my family and loved ones, right? Three, strategic values for maximizing your estate plan, right? And this is where some of your individual needs will kind of come into play and in kind of unique situations. The estate planning path is not the same for everybody, right? And so in general, the concepts that we'll discuss today are, but the individual components themselves are often tailored for our individual clients. Okay. Next is working with your financial professionals. And so we are just one component, the legal component or the lawyer component is just one piece to the puzzle today. So I'd ask all of you all to kind of keep in mind that you'll want to loop in your financial advisors. You'll probably want to loop in your tax folks and into your conversations to develop a full comprehensive plan, right? To make decisions with everybody involved. The estate plan is not static, so it's not kind of set it and forget it. So once we kind of get it there, you also want to kind of monitor it and maintain it. So it's really important to look for regular updates, and we'll give you some tips and clues of when those updates and when you may want to be paying attention to that, or how often you need to check on your estate plan, right? And there's a lot of different factors in that as well. And then lastly, talking about death, if any of you've done life insurance or anything like that, you know that these are hard conversations and often family members don't want to have them. They want to ignore it. But the only thing certain in life is death. And it's important to have those conversations because it's something that affects all of us in every way. So with that, we can kind of move on to the next slide. All right, so just kind of a general understanding of estate planning. What is an estate? You know, your estate is any type of assets that are in your individual name that you leave behind when you die, right? And in general, assets are divided into two categories. So there's real property and then there's personal property. So real property is real estate. So if you pass away with any kind of real estate in your individual name, then that real estate would be a part of your estate, right? Personal property is everything else. It's everything that's not real estate. And there's really kind of two types of personal property. There's tangible personal property, right? The stuff that you can touch and feel. And then there's intangible personal property. And then your intangible personal property is like your digital monies, your bank accounts, 401ks, IRAs, life insurance policies, stocks, bonds. Okay. And then your tangible personal property, this may be like cash, coins, furniture, art, collectibles, pets. Pets are personal property, right? So those are really the kind of the asset types. Um, Almost everybody has one of those types of assets in some sort of way. So a common misconception may be estate planning is only for the wealthy. Huge misconception. So if you all know Tennessee and Georgia, they don't have a death tax, right? So you're not paying any kind of estate tax or death tax on your assets at death in Tennessee and Georgia. Federally, right now, that bar is around $12 million a person or $24 million a married couple. So if unless your entire estate is looking at being above that value, you really don't have tax implications that you really need to worry about, at least not at this time. Now, in I think 2025, unless Congress acts, that is supposed to drop to roughly half, so about $6 million a person, or I think it's like $11.4 million total. And so we're all kind of waiting and see. That's a great example for why you would want to maybe review your estate plan from time to time. We do recommend if your plan or your assets are above that amount that you engage a tax attorney because there's going to be some strategies that they'll want to engage ideally to help you offset any kind of taxes that are owed upon death. Okay. Lastly, estate planning is not just about having a will, right? And so, what happens if you're incapacitated? You know, you can't make decisions for yourself, but you're still alive, right? Your will only comes into play if you pass away. Um, uh, what happens if you don't have a will, right? Then in that case, the state creates a will for you. So we'll discuss that in a little bit of detail too. Okay, and we can move on to the next one. So here are the real kind of components when we talk about an estate plan. I liken an estate plan to like a toolbox. And in that toolbox, you have different tools to use to achieve your various objectives. Not everybody will have all these tools. Some people will have all these tools. And so that's where we will really work with you one-on-one in a full-on consultation to discuss which tools are right and answer your questions about these tools. Okay. So really the first one in the toolbox are your wills. Okay. And your wills, most people are familiar with wills. Maybe they've seen something in a movie where somebody's passed away and the family gets around and the lawyer reads out the will and family starts fighting and whatnot. So wills are what most people are familiar with. What people often don't understand about wills is the only way a will has any power. There's got to be two things that occur. So the first is it's further obvious, but you've got to be deceased. So the person has to be dead, right? And then the second one, that will has to be submitted to probate. And that's what a lot of people don't understand. Hey, I made a will, I did this on LegalZoom, or I wrote it out, and I want my family to carry out my wishes. Well, the will itself has no power unless it's submitted to that probate process, right? And that probate process is a court process where your executor, the person that you name, in your will that's going to be distributing your estate or your assets, they would take your will and your death certificate down to the probate court in the county there, and they would open up probate. And when that happens, the probate court does a couple things. One, any kind of assets that are in your individual name, they freeze those assets because they send out an announcement that says that you've passed away. That's a public announcement, and they freeze those assets for a statutory period of time to allow any kind of creditors, anybody that you may have owed money to come and collect back against the estate itself. Okay. And so, for instance, if you pass away and you got real estate in your individual name and your will's got to go through probate or to allow that asset to pass, let's say maybe your children, whoever you're leaving it to, maybe they need to refinance it or they need to put it on the market to sell it. They're not going to be able to do that during that probate period, right? And so they don't have control over that asset until the probate is complete. The second kind of downside to probate is the cost. So probate in general probably is going to cost you $500-800 if you do it yourself, and just court filing fees and notice and everything else. If you go to an attorney to do it, you're probably looking at about $2,500-3,000, and that's for an uncontested will to maybe take it through probate. So certainly, if creditors or children or any kind of beneficiaries are in dispute over it, those costs can certainly rise. And there's a couple other things that you're going to name in your wills too. So you can elect kind of your final disposition. Do you want to be buried or cremated? And then you can deal with guardians for minor children. We'll talk about minor children in a little bit more detail here soon. But who, in the event that you or you and your spouse pass away, who's gonna take care of the kids while they're minors, right? And so that's all stuff that you kind of name in your wills. But again, the important thing about a will is for it to be valid, it's got to be submitted to that probate process. And that probate process for a lot is undesirable because it's public, it's costly, and it's time consuming. Okay. Now, if you don't have a will and you pass away and you have these assets in your individual name that you need to allow them to pass, then the state of Georgia creates a will for you, or the state of Tennessee will create a will for you, right? And there's we can discuss in greater detail how that goes, but typically they look for your spouse, and no spouse, they look for kids, and if no kids, they look for parents and brothers and sisters, and down the line to eventually the state just gets to keep it. And so if you have any kind of last wishes or anything like that, it's really important to draft will, because otherwise the state or the government's going to basically determine that stuff for you. Okay. Next is trust. And with trusts are a popular tool for our basic estate planning to avoid that probate process altogether, right? And so with a trust, think about a trust like an entity, almost like a company. And the goal becomes to get those assets into the trust while you're alive, or provision for those assets to go into the trust immediately upon death. And remember, we talked about those two types of assets. So the real property and the personal property. With your real property, the way that we put that into a trust is with a deed. And really with a trust, all you're doing is you're separating the ownership of the asset from the control of the asset. So the ownership of the asset is in the name of the trust. The control of that trust under a revocable trust is controlled by those that set up the trust. So the trustees of that trust. And with real property, we put that in with a deed, and our firm, could certainly help you do that, or probably any real estate attorney or title company could help you, transfer your property into a trust. And really, you can put any kind of property in any state. It doesn't have to be in Georgia into one of these trusts. And with the trust is always alive, so it doesn't pass away when you do. So remember when I said with your wills, you pass away and you have any assets in your individual name, then that's considered a part of your estate, and you would have to go through probate to allow those assets to pass, or allow the statutory time to pass before you can do anything with those assets. With a trust, you don't have that, so it's just business as normal. So the trust is always alive. It's like a company; it doesn't pass away when you pass away. So you'll name backup trustees, and you can outline how you want your assets distributed out of that trust. So that may be, immediately upon death. You may have minor children that you say, hey, at 25, I want them to get a third, and at 30, I want them to get a third, and at 35, I want them to get the last third of the remainder. So with a trust, you have a lot more kind of structure on how you handle things. As far as that personal property and how you get that into the trust, as far as the tangible stuff that we talked about, right, the stuff that you can touch and feel, we create an affidavit of transfer and bill of sale that just says whatever tangible personal property I have at the time of my death, I hereby put it into my trust. Okay, and so that gets all that stuff, the tangible personal property. Now, your intangible personal property, so again, this is all your digital monies, 401ks, IRAs, life insurance. At least with the tax stuff, like the 401ks and IRAs, you can't go ahead and put that into the trust without tax consequences, right? They're your retirement accounts and whatnot. So what you do is all of those accounts have a beneficiary designation on it. And for most of you all that are married, it's probably your spouse that's the beneficiary. And as long as that beneficiary is alive, when you pass away, it'll go directly to that beneficiary if you've got them designated. So, for instance, like life insurance. However, what we see a lot in real practice is, one spouse maybe passes away first, and the second one forgets to maybe change that over, change over a beneficiary, add a new beneficiary, and then the second passes away, right? And at that point in time, when the second passes away, there is no named beneficiary, right? So you're stuck having to take that will through probate or go through the probate process to really allow that asset to pass on down. Um, so for that reason, often we recommend that you keep your spouse named as a primary beneficiary, and if you do set up a trust, you consider naming the trust as the backup beneficiary. So that way, if your spouse is not alive, then those assets are going to dump into the trust. And so the trust ideally is a centralized place that you can kind of do all your giving from, right? You've got your real estate that we put into the trust with the deed. We've got your personal property that now we've either transferred by that affidavit or you've elected on the beneficiary designation, to go into that trust. Okay. There aren't any ongoing costs associated with trusts, and so it's basically a one-time setup fee, unless of course you elect for like a professional trustee or somebody else, or choose to pay the trustee. It's not like a company or an LLC where you have a Secretary of State filing. The revocable living trusts that we typically set up are they just follow your individual tax IDs, and so at the time, you don't need to go open up any other kind of bank accounts or go get an EIN number when we set these things up initially. And there are various types of trust, right? So there's trust really for everything. So the trust that we talked about is generally what our clients utilize. There's also like Medicaid trust. So if you have to get assets out of your individual name to be able to qualify for Medicaid in any way, shape, or form, there are pet trust, right? You hear a lot about it now that some rich person's dog, got left $2 million in a pet trust, and so there's pet trust. There's firearm trust. There's irrevocable trusts that are maybe are set in place for charitable giving or donations or to get tax dollars down if you're over that threshold. So there's really a whole bunch of kind of different types of trusts. And so we're really just barely scratching the surface there. And I encourage you all to reach out, with more questions about those if you have any kind of specific situations you want to discuss. Next, the powers of attorney. Powers of attorney are only good for while you're alive. And I'm going to talk about powers of attorney in this advanced directive of healthcare really at the same time. So they're really kind of both forms of powers of attorney. There's two types of these powers of attorney. So there's a financial and there's a healthcare. And essentially, all you're doing is naming somebody to make decisions on your behalf in case you're unavailable to, or maybe even simply, out of town, in some way, shape, or form. You can create powers of attorney that are very specific, or say, hey, I'm giving my wife my power of attorney to be able to sign my name to sell her house. Maybe I'm going to be out of the country or something like that. Or you can make them more general, right? I'm just going to go ahead and give my wife the ability to sign, my name or to be able to make decisions in the event that I'm unable to, right? The other way to create powers of attorney is upon incapacity. So if a doctor deems you incapacitated, then that person has the power to be able to make those decisions on your behalf, right? Often it can be a long road to incapacity. I don't know, if any of you all have experience, but sometimes kind of people lose it slowly, and it doesn't happen all at once. And so, that's another thing that we'll talk about in more detail on a consultation is the importance to particularly really consider going ahead and creating immediate powers of attorney, especially if you have a spouse or somebody that you trust close by. Healthcare directive, that's a power of attorney as well. That's a healthcare power of attorney. And you can just think about it, basically you can make, decisions as far as what you'd want healthcare wise. Would you want to be kept on life support? Would you not? Would you want your healthcare power of attorney to be able to authorize an autopsy or organ donation or your body to be used in a medical study program in any way, shape, or form? What would be kind of your wishes? Often with the healthcare directive will include a HIPAA release form so that your healthcare power of attorney can actually get access to medical records and stuff like that. And so that's really basically kind of the toolbox that we generally talk about in much more detail than I just did with you all today. And when we talk about estate planning, now there are some things that go along with this, such as deeds and affidavits. And there's additional documents for minor children, such as like a designation of a standby guardian, or a medical authorization for minor children. And then also these documents do apply to adult children as well, right? So children that may be off at college or whatnot, particularly with powers of attorney, those are going to be really important for them because they're an adult, right? And so a court may have to determine who makes decisions for them if you don't have one of these documents. Okay, we can move on. You're financial professionals, and so we do not give tax advice. I am not a tax attorney, and again, it's very important to involve your financial advisors, CPAs, and tax planners. We are just one component, of the plan. We can put the plan together for you, but it's good for you all to have advice, from those people that you trust as far as your financial goals, any kind of tax implications or goals. A lot of our clients have rental properties. A lot of them have ownership in businesses, and whatnot. Okay. Updates. So there's a lot of things that affect updates, right? So one, good old laws and Congress, right? They can change things on us. Back in 2019, for any of you all that are previous clients, they did a change in Georgia to that advanced directive of healthcare, right? And so that is one of those things that if you've done stuff before, then you may want to get that document updated. And so laws frequently change. Again, what we talked about with that threshold as far as the federal government and what they're going to collect, that's looking to change. I can only imagine with as much as we're spending right now on the federal level that they're going to be really looking for, well, where do we get that money back from? How do we pay that kind of stuff? And maybe that does come from estates at some point in time. And maybe you will start to see more estates enacting taxes and laws and that kind of stuff, or the federal government dropping those bars so that more and more people kind of qualify for that. Other big things are like marriage, divorce, birth of a child, business changes ups, all of that kind of stuff. All of those things are kids going to college. The kind of major life milestones and events are something that you'd want to kind of consider reaching back out. So if it's been a while since you reviewed this and you have questions and whatnot, we're happy to review anybody's documents, including if you did not get them from us, and answer those questions for you. All right, I think move on. And I saw, so we'll open it up to questions. We've got a couple minutes left here to do so. I believe I saw one come through the chat about checking accounts. And do you want to put your checking accounts into your revocable living trust? In general, it's kind of up to you on that front. Most people don't. So the checking accounts as well have what's called a payable on death. Some of our clients add somebody to their account. So you may have a joint account with you and your wife. So if one of you passes away, the other one basically owns and controls that account. To my knowledge, there's not any tax implications by putting your checking account, into the trust, other than the fact that you're probably going to have to file a tax return for the trust at that point in time if you do that. And so we really generally advise, and of course, talk to your financial advisor and your tax folks. We generally advise that you just make maybe the trust the payable on death, or the beneficiary designation on those accounts. So if it's you and your spouse, just like with your life insurance, and it'd be you and your spouse, and then you designate the backup as the trust. And so ideally, if you pass away, whatever is in that, they're just paid into the account itself. So, okay, good. I see another one up there as far as how much, maybe we've done wills for you in the past. So if you all remember, we service clients that are both on legal plans, like through their employers, these are like MetLife and ROG and whatnot. Chances are, if you're on one of those legal plans, almost everything is covered. There are different kind of coverage tiers, but if you're on one of the legal plans, chances are it doesn't cost you anything at all. If you're not on one of the legal plans, and I guess let's take a step back. If you're on one of the legal plans, next steps would be you just reach out to us. You get a free consultation, 60-minute consultation, which is a one-on-one that we'll work through together. And then if you are not on a legal plan, what we do is we can set up a 10-minute kind of introductory call that's a one-on-one, and we can discuss our fees and the costs, and that kind of stuff. And it's no cost, no obligation. If you decide to move forward, what we generally do is then we have a paid 1 hour consultation where we'll credit that back to any kind of products you get, and that paid consultation is 175. Um, let's see here. Let me get my chat up just because I know there's some questions coming in. And also we will follow up with all of you on this. And so feel free to submit these questions. If I don't get to you today before we run out of time, feel free to submit these questions to the SMA at smalegal.com. That's SMA at smalegal.com, and we'll make sure that we get right back to you as well. So I'm just going to run down the list here. We've got generally too, for updates, and so this goes back to you, Carson. Generally for updates, it's usually pretty nominal. It depends on kind of how much stuff we're changing and how long it's been. Sometimes it's just better just to do all new documents. We do offer a prior client discount. We do offer a discount for over 70, and we do offer a discount for our veterans. However, we can kind of go through that in detail. If you just reach out to us, and we can, run through that and your specifics, and you could give you a price on it. Some of the updates are as little as $50, $75, and some of them run upwards of, a couple $100. That's kind of general, about what to expect. We take a lot of wills and review a lot of wills from other states too. So if you did your documents in another state or somewhere else, we also review those. So good question on Georgia. Most states will accept to probate other states' wills, but what the difference is the state's probate process itself is different from state to state. For instance, like in Florida, they take a percentage of your assets. It's like 3% of your estate value to go through probate, which is really expensive, really time consuming. So you really don't want to go through probate in Florida if you can avoid it, right? Carson, I probably still do have a copy of your document, so I can go back and look. Again, we took over from Scott Murray and Associates. Scott Murray's still on board and of counsel, and I have access to pretty much everything he has scanned in. We have copies of almost everything. If we don't, or we can't find it, or if it's too far back, or I can't get Scott to produce it, then I'm happy to just basically recreate those documents for you. Yep. So this next question is: we created a will a few years ago. Is it possible and advisable to add an itemized list of all our assets as an addendum for the benefit of our beneficiaries? Yes, absolutely. So most in our documents, you can attach, you can put in really anything that you want with it, for really guidance for that executor or for that trustee. Now, if you want specific distributions to go to specific people, we need to make sure that we put that into your will that allows you to basically kind of attach that. Otherwise, they're going to look at kind of the four corners of the will, and if you weren't clear, or if they conflict with each other, your list conflicts with what you said in the will, they're going to probably default to what's in the will itself. That's probably a good point. It's really important to really kind of be clear and on the same page, and involve your relatives and those in this process as much as possible. Again, it's not a fun conversation. It's best just to hit your kids with it when they come to visit you for Thanksgiving or something like that. I'm just kidding. Well, great. No, I know that we're at time right now. And so I really appreciate you all coming out. Again, we do have this recorded. Please reach out to us with additional questions. We'd love to set you up with a consult and update any kind of documents that you have. Again, if anything significantly has kind of changed since the last time that you've done your documents, marriage, deaths, divorce, kids going off to college, grandkids, pets, firearms, really all of that kind of stuff, or just a lot of time's gone by, and you just want to talk to somebody about it and get that peace of mind. We're more than happy to do so. We will be reaching out to all of you all after this, and we do have this recorded. It has been a pleasure talking to you all, and hope that you all have a wonderful rest of your afternoon. All right. Thank you all.